Case on this morning's docket. That is case number 113149, State of Kansas v. Bryant Seba.
Good morning. Mr. Seba appears to counsel Michelle Davis, and I'd like to request 3 minutes for rebuttal, please.
3 minutes is granted.
This case came about. It's a summer night, evening hours. Mr. Seba he's 21 years old. He's on the porch of his residence where he lives with his parents. He's in a heated dispute with another young man in the neighborhood. He's pretty much jumped. There's 4 men that come to his house. He ends up being pushed down, and 2 men are kicking and hitting on him. Next door, there's some individuals standing outside the house. A man runs over and pulls one of the attackers off of Mr. Seba, which allows him to then run into his house and to get his rifle. The attackers turn on the man, and a woman comes over to help the man and stop that. And the one detail I left out is that Mr. Seba has been drinking and is intoxicated. So Mr. Seba comes back with his rifle, and he shoots the rifle. The police respond to the residence. He calls his dad, and he says, "I think I shot 2 men." The police respond to the residence. He says, "I'm the shooter," and is taken to the police department. His blood alcohol level is tested at 0.17, and he gives a statement. He's interviewed by the police a few days later. When he's sober, at that time he's remorseful because he's found out that he actually shot the woman who had come over to help. She was shot in the head once and died, and also she was 13 weeks pregnant at the time. And so the fetus, or what's referred to statutorily as the unborn child, also died. And one of the attackers was shot several times and severely injured. So as a result, the state charged Mr. Seba, and he was convicted of premeditated murder of the woman, premeditated murder of the unborn child, and attempted murder of one of the attackers. And we raised several issues on appeal. They're mostly instruction errors. And we also challenged the premeditated murder of the unborn child conviction. The 2 issues I'd like to talk about are the failure to instruct on the reckless versions of the crime, and also our challenge to the premeditated murder of the unborn child conviction, and then submit the remaining issues on the brief. So basically, in this case, the shooting was not contested. Basically, the defense here regarded Mr. Seba's mental state because the state had charged him with intentional killings. And Mr. Seba basically was arguing this was not an intentional killing. And the evidence to support that would be that he had told the police, this was during the sober second interview, that he had remembered being pushed down and kicked, that he had retrieved his rifle, that he was drunk and he wasn't thinking, that he was upset and he was in fear for his life, and he was just trying to scare them. He thought he was aiming above them. And that based on that evidence, the focus here isn't, the case law is fairly consistent on this point, that the focus is not on whether the homicidal act is a deliberate act, which would be a deliberate shooting. The focus is on whether the killing was intentional or unintentional. And so while there may have been a deliberate shooting, it was still a jury question regarding Mr. Seba's state of mind, and on that basis, the district court should have instructed on the reckless forms of the crime.
What was the distance between your client and the victims who were shot in this case? Between, do you know?
Not specifically by number. I know there was testimony that he was shot from the porch of his house, and it was the house next to his, and that the 2 people that were shot were standing on the property line between the 2 houses. That's what I recall. And it was dark out, although there was some evidence that was the moon. There was a moon, and maybe a porch light was on.
But the state's theory wasn't that he premeditated or had the intent to shoot the woman.
The state, right. The state's theory.
They proceeded on a transferred intent, didn't they?
Right. The state's theory here was that he was shooting at the 2 men that had attacked him. And I guess that segues me into my next issue, which is the challenge to the conviction for premeditated intent to
Excuse
kill
me.
the unborn child. Yes.
Before you get to that
Yes.
issue, counsel, our standard of review on the instruction issue would be clearly erroneous?
Yes, that's correct.
And have you now recited all the facts that you wish to recite in support of your belief that this was clearly erroneous not to give these instructions?
Yes, and just what's in my brief, if I missed anything, that there was evidence there that would reasonably justify conviction, yes.
All right, thank you.
So on our challenge to the death of the unborn child, basically, Justice Johnson, as you talked about, that's a common law theory of transferred intent. In Kansas, that's been recognized as you kill someone other than your intended victim. And so the classic example is the Jones case where the defendant was shooting at a gang member and he ends up killing a passerby. And so therefore the intent here is to kill a human being, and so the intent then transfers to the human being that is actually killed. So the district court on that basis instructed the jury that when a homicidal act is directed against one other than the person killed, the responsibility of the actor is the same as it would have been had the act been completed against the intended victim. And then we also have the Gaydon case where the defendant was shooting at somebody. He shot them, but he didn't kill them. And he ended up shooting and killing somebody else who was standing there. And on that basis, he was convicted of attempted murder of the person he shot at, the intended victim. And the court in that case upheld felony murder of the person who was not intentionally killed.
That's what I was going to ask you. Mm-hmm. This almost seems like the same as a felony murder. Mm-hmm. If you're in the commission of an attempt to shoot one person,
right,
and another person is shot inadvertently,
right.
That's what we see all the time, of robbery where something goes bad and someone's killed and that wasn't intended, but that's felony murder.
Right. Because it was an unintentional killing. And I think the best example that I can give...
But you're not claiming that felony murder should have been given as a lesser.
Well, it's our position that evidence doesn't support premeditated killing of the unborn child. That's our position here. And that's the only thing. They didn't charge felony murder or instruct on it. And the reason the state's claiming they can get 2 counts of premeditated murder, I'm going to try and give an example. Say you have a tall man and there's a short man standing behind him, and you intentionally shoot the tall man, and the bullet goes through and it kills the short man, but you don't know the short man's there. You can only get felony murder from that because you had a premeditated intent to kill the tall man. There's no premeditated intent to kill the short man. It was an unintentional killing in the commission of killing the tall man. Now the state here is claiming, if I shoot at the tall man, but I think it's Bob, I'm really trying to kill Bob, but the tall man's really Joe. Because the state can bring in transferred intent and say, well, it was a mistake. It's a mistaken identity. You weren't trying to kill one person, but you killed another, because that transferred intent just somehow keeps going. And therefore, if I shoot at somebody and I think there's somebody else, you can keep getting premeditated murder out of that. And that just makes no sense to me. I mean, the premeditated intent is to kill a human being.
I don't understand the logical distinction between if you have 2 people side by side and you shoot at one and you're a bad shot and you hit the other one, you've already indicated we have law that says, well, you can transfer that premeditated intent to the other one. But if they're standing behind and they shoot both of them, then you can't have the transferred intent. What's the logical distinction?
Because there's no intent to transfer. You intend to kill the tall man, you kill the tall man. And the way that's been interpreted in Kansas is the intent if the act would have been completed against the intended victim. Well, when the act is completed against the intended victim, there's no transferred intent.
Well, isn't the distinction in Gaydon that the conviction for the person who was in the intended target but didn't die was attempted voluntary manslaughter, not premeditated? But here we have the jury finding of a premeditated intent to kill the victim who did not die. So why can't that premeditated intent transfer? I mean, I think that's the distinction with Gaydon that you rely on.
Right, but the act's completed. The act's completed. In Gaydon, the act wasn't completed. It was attempt. But I don't think I have to distinguish this from Gaydon. Let's try this another way. Let's say that Mr. Seba had been shooting from the porch and he did actually, instead of the woman, it was one of his attackers there. right? So he shot and he killed the person that he intended to shoot and kill. There's no transferred intent. The act's completed. If there's a man standing behind that person who's also killed by the bullet, you can't get premeditated murder from that. Or if the person was pregnant and you killed another human being, you still couldn't get premeditated murder. The act's been completed. There's no intent to transfer.
But the act wasn't completed in this case, was it? Because the intended victim did not die.
But so that's what you're saying then. If it's a case of mistaken identity, we can get premeditation.
Well, why isn't it
Right
just,
away.
as Justice Johnson said, why isn't it just the case of a bad shot? I mean,
I don't
he's spraying bullets around and he's trying to kill the intended victim.
Uh-huh.
And one of the shots kills a bystander.
Mm-hmm.
Isn't that this case?
The difference is, in this case, is that it didn't just kill the bystander. It killed more than the bystander.
Killed two bystanders.
Right, but that's not the. If you want to recognize the doctrine that way, you can. But that's
Well, but
not the
isn't
way.
that-
That's not the way it's been recognized in Kansas. The intent follows the bullet is not the way it's been recognized in Kansas. If you read the Gaydon and the Jones case, and if you read the court's instruction in this case, it says the intent would have been the same had the act been completed. Once the act's completed, you've got your premeditating killing of a human being. You're done.
Yeah, I understand that argument. I just don't know how it applies here, given the fact that the intended victim didn't die. It wasn't completed. So therefore, the intent can transfer.
But are you arguing that the intent transfers to the woman and it can't transfer beyond that?
Because you have an intent to kill a human being and a human being was killed. That's one count of premeditated murder.
And he had premeditated to kill one person, that transferred to the woman, but it can't transfer beyond that to additional people?
Right, well, let's think of it another way. The way this should have been charged and instructed is he intentionally killed a human being who was later identified as Alexandria Duran. It doesn't matter the identity, it's the law prohibits killing a human being. We put the name in the jury instruction for the jury's convenience to identify the person, but that's not the point. So the only reason you're really instructing on transferred intent here is to make it clear to the jury he doesn't have to specifically intend to kill Duran. He just had to intend to kill a human being. And transferred intent instruction is a nice way of explaining that to the jury.
So if he not killed the intended target, but killed 4 different people, it would not suffice for premeditation on the 4 people?
Well, again, it depends on your circumstances. So if it's in my situation where it just depends. It depends on the circumstances. If you have one shot,
Well, let's
and
take this
intent to kill-
circumstance. He shoots from his porch.
Mhm.
He not only kills the woman who's pregnant, but also kills 2 other people. That wouldn't suffice for 4 charges of first-degree murder?
It would depend, and it would depend
What
on.
does it depend on?
Well, is he trying to shoot? It depends. Okay.
He's trying to shoot his
Yeah.
intended target, but he kills 3 other people and only wounds the intended target.
So he does.
So you
kill-
only
he
have,
does
under
kill-
your theory, since it says human being in the singular, it'd only be 1 count of premeditation and the other 2 would be somehow different?
Yeah, if that was his intent. If the intent here was to shoot one person, and then
He kills
bad
3
shot,
other.
He just keeps shooting, right? Right.
It
And
only
he- and he-
suffices, I don't understand.
Right. So then you've still got first degree murder. I'm just saying it's felony murder because he had a premeditated intent to kill one person, and one person was killed.
So his intent, his premeditation is limited by the number of people that he premeditates to
Yeah.
kill.
The
And
way-
then you can only transfer it. It's like it expires after you get one. You can't keep transferring it.
The way that this has been applied in Kansas, yes.
Okay.
And if you apply it further than that, then you're basically judicially creating that crime because it has not been interpreted that way in Kansas before. And in addition, you have the legislature saying felony murder covers that situation. An unintentional killing is going to be the legislature's already covered it. I mean, they've got a
The problem
statute.
is it's not, well, let's say we accept your premise here how do we know he didn't intend to kill two people when there were two attackers and he was angry and shooting at the attackers?
The state didn't charge it that way, did
I'm
they?
not disagreeing with that. That's why you have two convictions here. I mean, not two convictions, but that's why you have the attempted murder on the other person. I mean, that was a separate event. He was convicted of attempted murder for the other person. So there's no evidence in this case that he intentionally tried to kill the fetus, the unborn child. There's just no evidence of it.
Well, there's no evidence he intentionally intended or he intentionally killed the woman, Duran.
But
And it was prosecuted as a transferred intent,
But
right?
the state's theory was that he had an intent to kill a human being. That he was firing at those two people. I mean, otherwise, you might as well go back to my first issue, which is recklessness.
Is there any case that where we or any other court have explicitly said what you're arguing? I understand you're arguing that implicit in the definition of transferred intent, it logically leads to that conclusion. But is there any case that actually says, nope, you can only transfer intent once?
Well, my authority for that would be if you read the PIC instruction, and it talks about the responsibility is the same as it would have been had the act been completed.
So
Right.
You're making an argument from that language, not from a case
Because I
which
don't
has
think
held
there
this.
isn't a case in Kansas that addresses this. I haven't seen this.
Any common law case at all?
Not in Kansas.
Yeah, I mean, anywhere. Do you have any
Well,
authority
they
to-
are, but other states, their laws are different, and they're interpreting. I mean, in a lot of those cases, they're saying, is it reckless or not? They're not even talking about felony murder. So again, we have a felony murder statute that covers this. And again, it's what you're willing to. What the law should be at the time this crime was committed. This was the law in Kansas. If you want to expand on transferred intent, you're creating a law right there. You're creating something that didn't exist at the time that he did this shooting, because that doctrine hadn't been recognized. The only authority is the legislature's authority, which says this is going to be prosecuted as felony murder. I'm out of time.
We have any more questions? Thank you, counsel.
May it please the court, Chris Elslager appearing on behalf of the state. And since the court was talking about transferred intent, I'll jump right in there unless the court wants me to discuss another issue first. The court's well recognized that transferred intent is a well-established doctrine here in Kansas, and I think has the same confusion with the opposing side's argument as I do.
Why isn't that the creation of a common law crime when you do have felony murder that encompasses that very situation? You intend to commit inherently dangerous felony, and in the commission of that crime, you kill someone else. That would be felony murder. If he aimed at Brandon and hit Duran, that fits the definition of felony murder, does it not?
It could.
And if the legislature has created a crime that fits a factual scenario, and we have said there are no common law crimes, only statutory crimes, how can we develop a doctrine that creates another crime?
Well, the transferred intent doctrine doesn't create a crime. The crime is first-degree premeditated murder. The transferred intent doctrine is a well-established common law doctrine that allows the transfer of the element of the crime. It doesn't create a new crime. And this court has addressed this before, both Gaydon and in Jones. Essentially, the court has said, look, there are alternatives. You can use either one. And in Jones, the court said, under the transferred intent theory, this evidence supports the charge of first-degree intentional premeditated murder of the victim. Under the felony murder theory, precisely the same evidence supports the charge of first-degree felony murder of the victim committed in the attempt to commit an intentional premeditated murder, and so on. And basically, the court has said either one works.
Transferred intent is essentially an evidentiary rule, isn't it?
Yeah, essentially, yeah. Yeah, and this court has recognized, contrary to what my opposing counsel said, that the intent does follow the bullet. In Jones, they said the intent is transferred to the person whose death has been caused, or as sometimes expressed, the malice or intent follows the bullet. And I can't follow opposing counsel's argument. If let's say hypothetically that Mr. Seaby here had a more powerful rifle than a .22. Let's say he had a 50 caliber rifle, and Alex Duran wasn't pregnant, but there was somebody standing behind her. The 50 caliber bullet is got enough power, could go through her, hit the person behind her, and kill 2 people with 1 shot. The transferred intent would still transfer to both victims. I don't know of any case anywhere that's ever said that you only get 1 transferred intent, that it stops with the first death. I mean, what if, say, he intended to kill his victim by burning down the house, and he didn't know it, but there were 3 other people in the house, and they all burned down too. They died in the fire too. I mean, you'd still have charges of first-degree premeditated murder for all of those victims. There's no reason why it would stop with the first person. I found no case that says that. I'm not quite sure where opposing counsel has arrived at that as a principle. It doesn't exist. She would be asking you to make new common law with that.
I think she mentioned the PIC instruction spoke to acts completed.
Well, I'd have to go back and look at the PIC instruction, but the PIC is a guideline for instructing the jury, but it is not the law. It's supposed to inform the jury as to the law, but it's supposed to be modified and adjusted as necessary. So it's not controlling authority. But as the courts pointed out, the transferred intent was the premeditated intent to kill Brandon Wright, which I think is pretty well established in the record, that he intended to kill Brandon Wright, but he failed. Okay, he didn't complete the act. He killed 2 other people in the attempt to kill Brandon Wright, and that intent to kill Brandon Wright transfers to both of them. It doesn't stop with just one. And that's essentially that's her argument, is it has to stop with one, and that's not grounded in the law anywhere. Then, unless there are any more questions on transferred intent, I don't think I have any more to say on that. I will just briefly address the argument about a reckless second-degree murder instruction. And I would point out, I guess this goes to all of their arguments except with the respect to the photograph. None of this was objected to or requested at the trial, so all of these jury instruction questions are reviewed for clear error, meaning the court has to first find that there was error, and then if there was an error, then the court has to decide, well, are you firmly convinced that the outcome would have been different, but had the error not occurred? So it's a pretty high burden for the defendant to meet. In the case of the recklessness, I think all of the evidence points to intentional premeditated conduct, not reckless conduct. I mean, he stated an intent to shoot and or kill Brandon Wright or Zachary Wright. It was overheard by, I think, three different witnesses testified. They heard him say something like, "You're going to get shot or I'm going to kill you," as he broke away from the fight and ran into the house. Then he ran into his house. He went upstairs, got a rifle from a room upstairs, loaded the rifle, came back down the stairs, came back outside, shouldered the rifle, aimed it at the people in his yard, and fired. Not only did he fire, he fired once and hit Alex Duran. She fell. And he later, when he was speaking to police, admitted that he saw her fall. He paused, then started shooting again. He shot, I think, eight more times, and he hit Brandon Wright 5 times. That's all evidence of intentional conduct. That's evidence of intent and premeditation. He had the time to think about what he was doing. He stated what he was going to do. He went inside. He went through all the steps to get the gun, load it, come back outside, aimed it. Every bit of that evidence shows intent and premeditation. He did make one statement in his second interview to the police. His first interview to the police, he told them he just said, "I was shooting in self-defense. I got those guys. I got the guys that were getting me." After he found out that he hit Alex Duran, well, then he changed his story. He said in one statement, he said, "Well, I was just trying to scare them and shoot over their heads." But that's refuted by his earlier statement. It's refuted by the witness testimony. It's refuted by the physical evidence. The forensic evidence showed that the bullet struck Alex Duran in a downward motion, which is entirely consistent with him standing on his raised porch and shooting downward into the victims. So there is no evidence or no I mean, you could take that one statement and say, well, there's some evidence of reckless conduct, but it's not really. There's no substantial evidence of reckless conduct, and I would just point out the Clark case that I cited in the brief, which is a very similar kind of thing where the defendant shot his victim in the head, and then as the police showed up, he said, oh, it was just an accident, I didn't mean to do it. But that was the only kind of evidence of, if you could call it evidence, of reckless conduct. And this court said that the defendant's self-serving statement alone does not support a finding of recklessness.
Is this different from Taha, the case that
You'll have to refresh my
the
memory.
court reversed because the accusation by the state was the former police officer was laying in wait his ex-girlfriend, and he, despite his expert marksmanship, claimed that he was lowering his rifle and shot her in the head. But that statement there sufficed for us to, it was a requested instruction, there's difference, but
Well,
in
and
that scenario, we said the instruction should have been given.
There's factual differences too, though. I mean, yeah, it was requested. You have a different standard of review, but there's also factual differences here. Is that in that case, I think there was just the one shot. He said he was lowering his rifle and it went off. All right, but here we have more than one shot. We have one shot. The victim gets hit, she falls, and then he fires multiple times. And I tell you that five shots in the same target are not indicative of reckless unaimed fire. If you hit a human-sized target 5 times, you're meaning to hit it. So that said, there's just no evidence of reckless conduct, and certainly when you review it under the clear error standard, there is no possibility that the outcome of this trial would have been any different had a reckless second-degree murder instruction been given. I mean, the jury was instructed on a whole list of other lesser-included offenses, and of course found none. They found him guilty of the most serious crime that he was charged with.
In a factual question, and somewhere I remember reading something about the reference to this rifle having been modified for accuracy.
Yeah, that was in the. It's in the record. I can't recall exactly where. I think it was in his statements to the police that this rifle had been modified, had a heavier barrel, and I think it had aftermarket sights on it. I could be wrong, but I think that was in the record. And it was also in the record that Mr. Seba practiced shooting and was a good shot, and that's why Zachary Wright ran as soon as he heard the threat that Seba made that he was going to shoot him. He'd seen Seba shoot. He knew he was a good shot, so he's like, "Let's get out of here. He's a good shot," and he ran. Unfortunately for his brother and Mr. Ann, they didn't run, and that's why we're here today. But yeah, there was evidence that the rifle had been modified to make it more accurate, and there was evidence that he knew how to shoot and that he could hit what he aimed at. And I think the fact that he hit Brandon Wright 5 times shows that he could hit what he aimed at. And quite honestly, and the state's theory is that when he shot Alex Duran, he thought he was shooting Zachary Wright. I mean, he hit what he aimed at. He just didn't realize that the person he was aiming at was not who he thought it was.
Counsel, there is recitation about shooting from the porch, the elevated position, into, I believe, the adjoining yard. Is that correct?
Well,
I'm trying to get an idea of what the distance was between the shooter and the victims. Do we know?
I think it was measured out. I believe that in the record, actually, one of the KBI agents or one of the police officers measured it out. I didn't put it in the brief. I don't recall at the time. I think it was something in the neighborhood of 30 to 40 feet. They were standing, as my understanding is, they were standing sort of in where the kind of the properties adjoined in the front yard. But certainly, I don't think any more than 30 to 40 feet.
Thank you. Any further questions? Any further presentation?
No, Your Honor, I simply ask the court to affirm Mr. Seba's convictions.
Thank you. You reserve 3 minutes for rebuttal.
I think just once again, just point out the inconsistency between if you shoot at somebody and you hit them and the bullet goes through them and kills somebody else, you cannot get 2 counts of premeditated murder from that. You can only get 1 count of premeditated murder and 1 count of felony murder. And that inconsistency between expanding this doctrine of transferred intent to cover wherever the bullet goes.
And you base that statement on what?
Well, that's the PIC instruction I was referring you to. The responsibility of the actor is the same as it would have been had the act been completed against the intended victim. So once you shoot somebody and you kill the intended victim, you completed the act. There's no intent to transfer under Kansas law. So if the bullet keeps going, all you can get is felony murder.
And the PEC, does the PEC refer to any case law support?
Yeah, it does, and I'm sure it lists Jones and Gaydon, but there is case law support in there. So that was the law in Kansas at the time of this crime. So again, there's just going to be a lot of inconsistencies depending on the facts if this doctrine isn't given limited application. And that would conclude my comments unless there are questions.
Any more questions? I see none. Thank you, counsel.
Thank you.
Thank you both for your arguments this morning. Court will take this matter under advisement. At this time.